So far, in our discussion of potential legal reforms based on sociological knowledge, we've talked about two options. If we want to mitigate the effects of case structure on legal outcomes, we could try to hide the case structure through a process of desocialization, or we could try to actually change the case structure so that the cases are more similar from one case to the next, and we'd actually have more equality in case structures and thus more equality in outcomes. And one example of that was the incorporation of law by creating legal cooperative associations. A third option, if law isn't giving us the results that we think are good, well, stop using the law. Usually when you have a product or service you don't like, you find an alternate product or service. So the idea here is that if law has disadvantages or inequalities that we don't particularly like, we could always seek alternatives to law that might not have those same problems to the same extent. Alternative dispute resolution is a term both for these alternatives to law and for a social movement seeking to encourage them. So beginning around the 1980s, right around the same time people were concerned with this idea of the litigation explosion and that America had become too litigious and there were too many lawsuits, you saw a growing number of people advocating and calling for handling disputes without state courts. And so they called for alternative dispute resolution. And most of the time what this meant was some form of settlement, such as mediation or arbitration, but settlement that was more informal and less authoritative than the courts of law. And so this movement had some success in establishing mediation centers all around the country. And you might not be aware of it, but if you Google in your area, you can probably find a mediation center near you that is an alternative to taking a case to court. If you have an issue with your neighbor or some business partner or whoever, instead of filing a lawsuit, you might be able to take it to a mediation center. People have also advocated the creation of what you might call neighborhood courts, things that are much more local and much more informal than a state court would be, rather than going to have your case heard amongst strangers who are high-status professionals. You have your case heard among people from your area who are not professionals, just people who know the local community norms and can give their 2 cents on how things ought to be handled. And you've seen some kinds of hybrid creations, such as California's Rent-A-Judge program. This is actually a business that allows you to rent a retired judge to hear your case, and he treats the case as if it is a normal formal court case, but of course, since it's a retired judge, he has no authority to enforce his decision. But the purpose of this is people agree beforehand to abide by this judge's decision as if it was a legal trial, making it a form of arbitration. And, if maybe one of them does want to go to trial later, they could take how this rent-a-judge decides things as an indicator of whether they're likely to win or not. And the idea is that this rent-a-judge is something that's much easier and cheaper to get access to than an actual trial in the California legal system, where your case might not be heard for a year or two, depending on how many cases there are waiting in line. You just call the rent-a-judge and he shows up next week and you get your case heard for a flat fee. Proponents of alternative dispute resolution point to some advantages that they claim that these alternatives will have over courts of law. And most of these advantages stem from the fact that these alternatives are less formalistic, less adversarial, less one-sided. In other words, less authoritative. They also stem from the fact that it's not dominated by professionals and doesn't require, say, hiring an expensive attorney. So generally speaking, these alternatives are said to require less time and money than a legal trial, and to be more responsive and flexible to the needs of people. Because the thing is, people have a lot of conflicts that they might want settled or handled in some way or resolved peacefully, but the legal system only responds to a limited number of things. And so you see these interesting patterns, like people suing each other over things that aren't actually what they're mad about. I'm mad because, your son dated my daughter and I don't like your son, but I can't sue you over that. So I sue you over the fact that your driveway kind of comes across my property, even though I wasn't really mad about that before. I'm mad about something else. And so a lot of times legal cases aren't actually getting at the heart of the real conflict, because the real conflict isn't something that's legally relevant. And you see all throughout the country that studies of these lower courts find court clerks treat most cases people bring to them as garbage cases, things that aren't actually matters for the law, and they will often just turn the people away and their conflict doesn't get resolved. Well, if it's a local court and not a formal legal court, you could have a lot more flexibility. These mediation centers could take care of things that aren't strictly speaking legal matters, but still you want a third party to help you talk things out and come to some peaceful resolution. Another proposed advantage is that these alternatives because they're less adversarial and less costly and carry less threat of big punishments and big damage awards, they tend to prevent escalation. They're less of an all-or-nothing war. And so because there's less threats and less risk of a severe outcome and a one-sided outcome, there's more room for conciliation. There's more room to compromise. There's more room to repair the relationship and have the two parties talk things out and come to some mutually agreeable conclusion and resolve the conflict in a conciliatory way that brings some peace back to the community. Versus if you just take someone to court and fight a big legal battle, and whichever side wins, you're probably going to hate each other's guts after that. One advocate of alternative dispute resolution is a legal scholar named Nils Christie, who wrote a paper called Conflicts as Property that's assigned for this section. And he says, one disadvantage of taking your cases to court is that you're losing all these opportunities for the victim and the offender to participate in their own dispute. And you're losing opportunities for members of the community to participate in ways that could help clarify, exactly what are the social norms in our community. What behavior will we tolerate? Who do we hold responsible when things go wrong? Who's at fault, or do we share blame? All these kinds of complicated issues that we might otherwise talk out with each other don't get brought up because in a court it's all down to some narrow formal rules and yes or no decisions. And he says that in modern societies, the legal system effectively steals conflicts from the disputants. Like, conflicts are something we should have ownership of and take part in. And instead, they're kind of being taken from us and dominated by these professionals. And we just kind of go along with what the professionals say. Okay, you've got a law degree. I don't know the law. You tell me, you tell me. Really, we should be the ones handling the conflicts ourselves according to our own cultural norms about what's ethical and right in our communities. And we should be focused on clarifying what's expected behavior of community members and on trying to repair the social damage done by the conflict. And these professionals deciding things very formalistically don't do that. And so he advocated that we move away from a legal system where professionals dominate conflicts and basically steal them from the people who might be handling them otherwise, to a system that's more oriented towards lay people, people who don't have law degrees and fancy educations, and is more oriented towards common sense notions of right and wrong. And a court that's more victim-oriented. It's about not, what the legal categories say, but what would help the victim. Would it help you to talk to the person who victimized you and explain how you feel and what they did and ask them what made them do it? Would that confrontation help get things off your chest and resolve the situation for you? Would you rather have that than them just going to jail for a couple months and then being back on the street? So what does the victim want here, and what will help people involved in the case? And he thinks that the formal legal system doesn't do this, but alternatives such as mediation centers and community courts might. Another advocate of alternative dispute resolution, Richard Danzig, said we should even extend this to criminal law. We should have a decentralized, localized criminal law system that is parallel to the official system. And this system could have things like community courts. It could have things like local parapolice, people who aren't fully trained and empowered to be cops, but they're more like local people who have sort of night watchman or neighborhood watch type of responsibilities. And, in a lot of neighborhoods, people have hostile relationships to the police and vice versa. And one way you could try to compensate for that is having some sort of local force that's somewhere between police and civilians, something that's like a layer in between the state and the people that might be a little bit more trusted and friendly because it's local. And so it could be like your point of contact to the legal system, and they could handle smaller things on their own in a more conciliatory way. And when serious things happen, they could refer it to the real police. So we talked about some proposed advantages of alternative dispute resolution. It could be more conciliatory, less expensive and formalistic, less off-putting to people who are scared of the all-or-nothing nature of the legal system, and more oriented towards being flexible towards local variations in morality and cultural norms, and more flexible towards the desires of the victim or even the offender or the community members involved in the case. But there, of course, people will also point to disadvantages of alternatives, and some people will say that the advocates of alternative dispute resolution go too far and forget about some of the reasons we depend on law in the first place. For example, sometimes people want authoritative settlement. We've talked a lot about how authoritative settlement can turn people off and make them scared of the legal system, and that's a pattern you see, but sometimes we want authority figures with a lot of power to punish deviance. If somebody has assaulted me or raped me or someone I care about, we don't necessarily want the law to come in and say, all right, let's have some social repair, make friends with your rapist or the person who assaulted you and try to get along with them. It might be, I want them to go to jail because they're a dangerous person or they deserve punishment for what they've done. And so some critics will counter that, one danger of pushing alternative dispute resolution is it might push people towards things that are conciliatory in situations where conciliation really isn't to their benefit. Like you might be trying to encourage a abused spouse to go back to her abuser rather than punishing him for abusing her. Another problem, and this is something that anthropologist Sally Ingle Mary points out, is that there's a reason modern societies have less of this kind of informal settlement than tribal societies do. There's a reason we don't have community courts and neighborhood moots and these things you see in more traditional settings. That's because modern social structure just isn't conducive to it. To have a community court and community justice, you need a strong community. And in a lot of areas of modern society, you don't have that. You have these suburbs where people move in and out constantly and have lots of privacy, and nobody even really knows their neighbors well or plans to be there for a long time and needs to get to know them well. And so it's hard to have these community-centered approaches without the appropriate social structure of strong social networks and people with ties of intimacy that they trust each other to hear cases and give their 2 cents and that they're motivated to try to come to some resolution. So you need to find places in modern society where we still have this social structure conducive to things like mediation or community-centered approaches, and you can't always find that.